Thank you for joining our webinar on managing building contracts and getting paid at the end. This presentation is primarily going to look at what the difficult clauses are in your RBN contract and how to deal with those clauses and how to make sure you're getting paid for your variations, making sure you're getting paid for your final claim. I am a lawyer. I've been practicing for many years. I regularly appear in VCAT. We have an office in Sydney. We have an office in Melbourne. I'm a panel lawyer for the Registered Builder Network, and we act for anything homes and most of the trades in the industry as well. Now, what we're going to look at is first cash flow. And at the moment, cash flow is king. And normally in the business or in building, cash flow is always king. And so you got to look at debtor management and how to manage your clients. And so we're going to go through all the different clauses, in particular, the ones that are most difficult. So how to manage your contract generally? First of all, you want to make sure that you have a subcontractor's agreement, if possible. A lot of subbies might not agree to sign off on a subcontractor's agreement, but if you do get a contractor to sign off on a subcontractor's agreement once, you can put a clause in that agreement that essentially says that those subcontractors will always be bound by that agreement moving forward for every future job that they have with you. And what the major terms of that subcontractor's agreement says is normally a commencement date, a completion date, liquidated damages, making sure they comply with their OH&S regulations and laws. And the most important thing is being able to pass on those liquidated damages. Your RBN contract says that a homeowner can claim liquidated damages against you if you delay the job. And you also have a clause that says that you can claim consequential losses or consequential delays against the owner. But if you don't have a subcontractor's agreement, you're not able to put those delay damages onto the subcontractor. The biggest time you always find issues with this is around Christmas, November, December, when everybody's busy. You might have a contractor stand you up. I've had a lot of cases where you've teed up all the jobs, you've teed up your concreter. After your concreter, you then got everybody else coming in after. And if one person doesn't show up on time, it stuffs up your entire program. And you want to be able to pass the buck on to that subcontractor who did not show up. And that's the importance of having a subcontractor's agreement. You want to make sure that your schedules in your contract are pretty accurate. A lot of people will just say builder's range. Now, what does builder's range mean? Do you have a specific provider where you buy your goods? Do you have a specific brand that you normally get? Builder range might mean something to you, but it doesn't mean anything to a homeowner. And if it doesn't mean anything to a homeowner, when it comes time for the selection, they might want one kind of tile. You say, no, you're only entitled to my range, which is that range, and there could be a dispute. And the main purpose of a contract is trying to limit that dispute and making sure the parties understand exactly what they're getting. Same thing as for the selection of stone and whatever it is. When you're putting in your schedules and selections, it's important to be as specific as possible. Liquidated damages. Normally, a homeowner, if they have legal advice, they're going to be trying to get liquidated damages, which is the equivalent to the amount of their rental per week in their alternative accommodation or their mortgage payments. And so they're going to be wanting $600–800 a week. There's no obligation for you to put that in. So the RBN contract automatically says, I think it's zero if there's nothing there. And if there is something there, you should also have a matching clause. You got to be very careful by including high liquidated damages, and you want to be trying to negotiate that as low as possible, because the higher the liquidated damage it is, the more likely that's going to get knocked off your final claim if you don't complete it on time. reading the RBN contract and understanding what it says is really important. And I really recommend everybody to sit down, no matter how boring it is and no matter how tedious it is, sit down and go through it page by page and read it and understand it. And I'm going to focus on this presentation, which clauses that you really need to reread and make sure you understand and try to drive it into your head so that when an incident happens, you know, oh, that's that clause. Let me go and read it and follow what that clause says. And so that's why it's important having an idea of what those important clauses are. And not being afraid to suspend works or issue a default notice. A lot of my clients are very afraid to exercise their rights under the contract. And a lot of time you have difficult owners. And when I say difficult owners, you have people coming on site when they're not supposed to. You have people coming on site and talking to your trades, asking your electrician to put extra sockets in, asking extra stuff, and then you get a bill from your subcontractor later for all these variations that you didn't know about. It's really important not to let the homeowner on site. And I always tell my clients, what's important is being a professional builder, not a friendly builder. It's very difficult to understand the difference, but friendly is saying, oh yeah, I'll give this to you for free, and oh yeah, I'll give that to you for free, and yeah, come on out and have a look whenever you want. And that it bites you at the end, because at the end, after all the variations, they aren't going to pay you because you verbally agreed to everything and you said you're going to give it for free. And when you actually start accumulating all these freebies that you've given, you end up realizing that it's just costed you your margin. So being professional is following the terms of the contract, getting your variations in writing, making sure your client only comes out when they ask to come out, and make sure there's someone on site from your company. And the reason that we always say that they can't come out to site is we just say it's against your OH&S, it's against your insurance policy, it's against your OH&S policy. So they're actually not allowed to come out, because if they got injured on site, your insurance might not cover them. Or it's against your OH&S, and if they injure themselves, you're going to be liable. So you want to make sure that you're present. They're not coming out all the time. And you can suspend the contract if they continue on doing that. You can also issue them with notices if they're interfering with you. So this is the important about understanding those clauses. The other thing is looking at inconsistencies and inaccuracies in the contract. I have a case right now, and it's the second case I've had in fairly recently, which is phenomenal because I can't believe that this actually happens. But it's where a building surveyor or even city council has approved 2 sets of drawings. And at first they look identical, but they're actually not. One drawing might not match the other, and you don't discover there's an issue with those drawings until later. So what's important is actually having procedures in place in your business and going to Officeworks and paying $3 for a receive stamp. And when you're given something, if it's not by email but physically, you put a receive stamp on it and you mark it down. If you get it by post, you have an incoming mail or outgoing mail register, so you know what you actually received. I have a case right now. Again, the drawings are different, and my client had a bunch of problems, and he's never known why there were so many issues with the job. And it's not until now that there's a dispute, and now that the experts engage, and now that a lawyer is engaged, that we've just found out that he hasn't had the right set of plans. That's actually the owner's fault. It's not your fault. But you've got to prove that you never had the right set of plans. And if you can't prove that you had the right set of plans, then it's he said, she said. So it's just starting to tighten up your internal policies to make sure that you understand what your obligation is when it comes to proving things. If you have stamps on it, it's not he said, she said. It's just simply saying we have an internal policy. Everything that comes in by post, we stamp. Everything we receive, we stamp. This was stamped on this day. We don't have a stamp on this document. It means we never received it. We'll get into the notice of practical completion and keeping your records later on, but let's just get straight into cash flow. This is a very amateur drawing that I've done. It's quite simple, but it explains exactly what is happening. So you've got your homeowner, you got yourself underneath it, and once you have your progress payment, you then you issue your progress claim, the owner pays you, and then you normally pay all your contractors. Now, this is a no-brainer. It's quite obvious. If you don't get paid your progress claim, you can't pay any of your contractors. If you can't pay any of your contractors, instead of you making payment towards them, they're now coming after you. Depending on the size of the building you're dealing with, you can get in a lot of troubles. You know, as you get bigger, you have bigger projects, and as you have bigger projects, you have bigger expenses. That includes buying elevators, even in some really fancy homes. But you end up being on the hook for these obligations, and they will come after you. And the process is quite simple when it comes to a tradie trying to come after you. I did this work, I sold you this good, and as a result of me selling you this good, you owe me this money, no dispute. There's no dispute about it. I issued you an invoice and you never challenged it. Your carpenter could say, there's no defects, it's a perfect job. And if you don't agree to pay them, they can issue this document, which is called a statutory demand. A statutory demand is a very technical document, but lawyers like to use it quite often. And the purpose of it is to get immediate payment within 21 days. And what that basically says is, we have an undisputed debt. If you don't pay that amount within 21 days, we'll file an application in court to wind you up. And if you don't file an application in the Supreme Court or federal court to set that document aside, you're automatically insolvent. And if you're automatically insolvent, every single homeowner who has a contract with you can now terminate, because there's a clause in every contract and in the Domestic Building Contracts Act that says that if you become insolvent, the contract can be terminated immediately. So what a lot of homeowners will do is, when there's a delay by a builder in building the project, the only way for that homeowner to get their home warranty insurance is to sue you in VCAT, win against you in VCAT, get a judgment in VCAT, and then after you don't pay that judgment, then they can get their home warranty insurance. Home warranty insurance only kicks in once the builder disappears, once the builder dies, or once the company has gone into liquidation or administration. So homeowners will actually go looking for tradies and say, I'll pay your legal fees. Can you get one of these documents issued? Because that prevents me from actually having to sue the builder. They can actually fund the tradie to issue the stat demands. They don't pay, and you've automatically committed an act of insolvency. The homeowner doesn't have to sue you anymore. They can now go straight to their home warranty insurance because you've committed an act of insolvency, and then they can wind you up, the creditor. So if you see anything like that, you have to be very careful. A lot of builders will use their accountant as their registered office. If you use your accountant, most accountants have a very strict policy of all the mail coming in, all the mail going out, and making sure that when they get it, they scan it and send it to you. If you ever see one of these documents, you must know that you have to act immediately. You have 21 days, or else you're in a lot of trouble. You can set it aside on grounds that there's a dispute, on grounds that you have a claim against the other creditor, and so on. But just make sure you have policies in place. Now, during COVID-19, they've actually changed the law. It says that 21 days no longer is 21 days. It's extended to 6 months. They've also said that you're not allowed to issue one of these for the next 6 months if the debt is less than 20,000. Normally, it's only when the debt is 2,000. But all I want you to do is see this and understand that if you see it, you got to act upon it, and not to ignore it, not to delay it. Now, the most common disputes that we see is between the homeowner and the builder, the subcontractor and the builder, and the builder in terms of business partners. So let's look at the homeowner and builder. That's the most common, obviously. And the main cases that we see are issues of inaccurate documents, hidden site conditions, and that's mostly in relation to home improvements, so extensions, or excavation. And then variations are very common, prime cost items, liquidated damages. These are the ammunition clauses that homeowners will use to not pay you, or to negotiate a discount to the final claim, or to not pay your variation. So if we look at putting things in writing, I try to drill this into everybody's head. Put it in writing. I don't know how many times I can tell people put it in writing and they don't. The fact is that the law says in the Domestic Home Buildings Act, you got to put it in writing. You got to put extension times in writing. You got to put progress claims in writing. Everything has to be in writing, and it's the law. And if you don't put it in writing, then you have the issue that it might not be enforceable. And you might not be able to claim against the owner later if it's not in writing. And there's been an update from the High Court, which I'll get into shortly about that. So let's look at accuracy of documents. When an owner provides you with the drawings, engineering drawings, architectural drawings, the owner automatically warrants that those documents are good. Those documents can be relied upon by the builder, and if there's any issue in those documents, then it is not the builder's responsibility to sort that out. I just have a case right now where there was actually a steel beam that wasn't correct, and the owner forced the builder to go and to have it fixed and pay all the costs for it. But I don't know why, because it was the owner that supplied those documents. So the owner has warranted that those documents can be relied on. And I always say a builder has been hired to build. That's it. You're hired to read the documents you're given, and you're hired to build. And if you're given documents that have issues with them, that's not your responsibility. The only responsibility you have is to follow the terms of the contract. And that says if there's discrepancies or ambiguities, then you have to go through and look at what you need to do. And it says there's going to be, in clause 3.1 of the RBN contract goes through the priority in terms of the documents. And then it also says that you must provide written notice and specify what the issue is. And you got to explain whether there's going to be estimate costs to fix it, or there's going to be a delay. And if there is, you got to tell the owner and give them 7 days of what you recommend they do going forward. So pay attention to that clause, because if something happens, you know that there's a process in the contract to deal with that. I've already talked about getting 2 different sets of documents, and I've already talked about a situation where it's normally the owner who's provided the documents. A lot of my clients have tender documents or pre-contract tenders that they give to the owner, and they say, we are going to assist with obtaining the engineering and the architectural drawings for you. What you got to remember is that if your contract is a major domestic building contract, you got to make sure that it's actually compliant. So you shouldn't be the one that's paying for the engineer or the architect. You should just be the one that's facilitating the arrangement, and then making sure that the homeowner pays the architect and the engineer directly. Because if they pay them and put in your documents that it's their documents, because if there's a problem, it's not your problem. Now let's look at latent conditions. Again, it's one of those clauses that pop up all the time, especially in renovations. A lot of times people will look and they'll put an extension on, but they'll put a clause in that says, we're not going to deal with the footings from the original home, and we're only going to put the extension on. But as a result of that extension, the front of the house starts sinking. As a builder, you technically are responsible because, potentially, because even though your contract explicitly excluded it, you've been hired as the builder and you should have known better. You should have known, a reasonable builder would have known that that would be an issue, and you should have told the owner, I'm not going to put this extension on unless this is all looked at, because I'm not going to be responsible for this part of the building. And if it does sink, I don't want to have any issue later on as a result of the works I've been performing. So there's again a clause that deals with the process of what you need to do when you see an issue like this. And it's really just identifying these clauses, drilling into your head. When you see this kind of scenario pop up, remember you got to look to your contract and see what it says. Make sure you obviously get a geotech report. Make sure you ask your client whether they have any other reports. Make sure the report is new. I have a case right now where there's a house sinking, and the reason it's sinking is because there was a geotech report obtained many years ago. The next door neighbors it was a vacant lot next door previously. When they actually started building and gave the geotech report to the engineer to do the drawings for the house, they gave an old geotech report. So the engineer went and did all the drawings and didn't know that there was a house next door. And they also didn't know that there was a tree that had just been built that have roots going into the land, which changes the soil. And as a result of that, when they actually built, they ended up building without knowing about the tree roots that were in the land, because the engineers normally don't come out to site to inspect. So make sure it's a new report, force them to get a new report, make sure it hasn't changed. You can look at Google Maps and you can actually look at a timeline from an aerial view and see whether there's been any changes from when a geotech report was done 2 years ago to now. It's important to make sure there hasn't been any changes, especially when you're building new suburbs or if there's vacant lots or looks like a new home next door. Some people talk about this 2% rule. The 2% rule is, oh, I don't need to get a variation in writing because it's not going to increase the contract price by 2%. I normally say that's crazy. Just get it in writing. If it's not in writing, you now have to prove that it was agreed and it's verbal. And you don't actually have to put a variation in writing if it's going to increase the contract price by less than 2%, but that's only if it's the owner's request for variation. It's not if it's a builder's request for variation. It's a one-way street, and a lot of people don't know that either. But at the end of the day, I say ignore that 2% rule. If you're aware of it, it basically says you don't need to have it in writing. Just put it in writing, because at the end of the day, if you look at a court case, I always say a verbal agreement is almost as good as a written agreement. The only difference between a verbal agreement and a written agreement is you have to prove a verbal agreement. A written agreement, you just show the document. A verbal agreement, you have to sit down with the lawyer and you got to go through word for word. I said this, she said that, he said that, she said that. We were at this location on this day, and then it's your word versus their word. So what's really important is just get it in writing. There's no reason why not to. And especially with technology these days, you can actually put a special condition into your agreement, and the RBN contract has this, which is the Electronic Signatures Act. And the Electronic Signatures Act says that electronic acceptance is deemed an acceptance. And we've actually put special provisions into the RBN contract to allow email acceptance of a variation. So put it in writing. That's the most important aspect in all variations. And there are steps that you need to do. If there's going to be a variation, you got to tell the owner if there's going to be an extension of time. So whenever you issue a variation, think extension of time at the same time. There's going to be a variation. Well, what's the cost of that variation? How long is it going to take? Is it going to result in an extra amount? And can I charge now? Never charge at the end. All variations should be charged at the next progress claim or when it's complete. And you can take a deposit as well for that variation. But a lot of people just leave it to the end. And if you leave it to the end, you're risking not getting paid. And this is what the legislation says about the 2% rule. So it is allowed, but again, I don't recommend it. There is an out of the agreement with an owner and builder in circumstances where the contract price has gone up by 15%, or where the job now takes more than 1.5 times. And so if there are unforeseen variations, I normally talk about this in a situation where the builder just says, okay, go excavate, and I don't know how much it's going to be. It's going to be about $1,000 a day. Just go excavate. And you say, oh, it's going to be about $12,000, and it ends up being 40. And the builder says, well, that's the cost. The reality is that you should have actually stopped the excavator at around the $12,000 mark, or even before they got there, the minute you discovered stone, or the minute you knew that there's going to be an issue. Because rather than that homeowner now paying an extra $30,000 in excavation, they might be able to just go back to the engineer, or might be able to go back to the architect and do a slight variation that means that the excavation changes slightly. But as a result of that slight change, the owner now gets to save the $30,000 in excavation costs that otherwise they would have normally done. So you got to make sure that if it starts going past what you expected, you stop it and you make sure the owner understands exactly what's happening. Prime cost items, provisional sum items. You are required to give notice of the selections, and you got to put an allowance next to it. You got to be very careful when you're quoting a job, and be very careful in filling out this schedule when you're doing it. A builder has an obligation to act reasonably in setting the allowance. If you go and say air conditioner $4,000, but you know it's a split system and it's going to cost no less than $8,000, for instance, then you haven't acted reasonably in the costing, and there is a claim or going to be a dispute when the homeowner goes to make a selection. They can't find anything worth $4,000. So you need to be very specific in what they're going to get and what your allowance is, and making sure that your allowance is reasonable. When I get into talking about writing down the prime cost and provisional sum items, you want to be specific. If you look at any dispute, if you look back at all the different cases you've had with your owners and why there was a dispute, it's probably something stupid. It's probably something about the kind of paint. You didn't mention Dulux, they want Dulux. It might be the timber floors. You didn't mention this, now they want that. You didn't mention the kind of tiles, and now they want that. They're always trying to get more. Depending on the range, the price range of your contract, a lot of people are building their home, and that's their dream home, and that's why they're having it custom built. So they want their steak on a McDonald's, for a McDonald's price, whatever that saying is, right? They want their dream home at the price that you're offering it to them. And so they're always going to try to get more. And I always find the most difficult clients are the ones that are in the contract price is around 300 to 700,000. Those are normally the most difficult clients because they're on a budget, and with that budget, they want to get as much as they can from that budget. And if they start asking for a lot of variations, you have to be conscious. You got to be very careful in that circumstance because they probably have a mortgage, and they might not actually have the money to pay for that variation. And they might convince you that they'll pay you the variation at the end. And when it comes time to get paid at the end, the bank won't approve any other variation, and you won't be able to get paid because they don't have the money. So be very specific, get everything in writing. Fill out your schedules. The more detailed, the better. If you have images, images are good. The biggest trend with all my clients now is actually doing a proper selection schedule. These are our builder's range. Here's a picture. Here's a picture of what you're getting. Here's a link to the website of our supplier. This is actually what you're getting. And if you don't want that, then you tell us now and we'll recost our contract. So to get a smooth completion, get paid for your variations, be careful about your liquidated damages, get everything in writing. In terms of adverse weather, issue extension of time notices. There's been a lot of floods recently. There's a lot of being very serious weather issues, fires, everything else. Make sure you issue your extension of time notice, because in the past, VCAT has not accepted someone putting into court a link from a website that says it was raining on that day. That's not good enough. A lot of builders have a diary. Diaries are excellent. Write in your diary. I couldn't go, it's pouring out today, blah, blah, blah. Issue an extension of time. The next one is subcontractor disputes. These can be very scary because the subcontractor, if they know how to use the law to their favor, they actually have a lot of ability to force you to pay. And that's the Building Construction Security Payments Act. That is, when a contractor issues you an invoice, that is a progress claim. You now have 10 days to respond to that claim to say whether you agree to it, reject it, and if you reject it, how much you're willing to pay and how much you're not willing to pay, whether there's any defects. If you do not do that in 10 days, a subcontractor can apply to the court and get automatic judgment against you with no right of defense to you. And that's because of the legislation that protects contractors. In domestic home building, a lot of contractors don't know how to use it, don't use it properly. But if you get an invoice from a contractor, make sure you challenge it. If you don't agree to it, you have 10 days to challenge it. If you do challenge it, then what that means is that that subcontractor now has to file an adjudication application rather than going to court to get an automatic judgment. And then there will be a mini hearing on whether you owe the money or not. So just remember, you have 10 days, you need to respond to their invoices within those 10 days. I started at the beginning talking about subcontractors' agreements. They're very important. They should be detailing the inclusions, the exclusions, the commencement date, the completion date, the liquidated damages, which should match what's contained in your RBN contract. And the reason why it should match it is that you can't just say to a contractor, you're going to pay me $1,000 for every day that's late. That's called a penalty clause, and a penalty clause is not legally binding. Your damages must be the reasonable expectation of what your loss is. So your liquidated damages should match what's in your principal contract with the homeowner, because if you delay as a result of the contractor delay, then you're going to have to pay the owner that amount, which you can then pass on to the subcontractor. You have a lot of holding costs as well, scaffolding, fencing, all those other items. You got to make sure that your liquidated damages are being covered by the subcontractor if he stuffs up your entire construction program. There's another clause that we often put into these subcontractor agreements, which says, if there are defects, we don't have to pay you. We will only pay you once you come back and fix that defect. If you don't have that in your contract, there's nothing for you to point at to limit their ability to say, no, I'm not coming back unless you pay me. That's normally what you get. You go and say, oh, there's defects, and the contractor says, okay, that's fine, pay me first and I'll fix them. But if your contractor agreement says, no, we don't pay you until you fix them, then they're bound by the terms of the contract. A lot of the bigger contracts have retention sums. If you can get a contractor to put a retention sum into in a subcontractor's agreement, that's important. That's basically saying we're going to hold back 10% or 5% or 10% of your contract for a period of 3 months after the completion of this job, because you won't know that that carpentry work is defective until you reach completion and the homeowner gives you their defect liability list or their defect list at practical completion, and you want to now call back that carpenter to go and fix the work. And if they don't agree to fix the work, rather than going and hiring someone else and paying for that and having to sue them to pay the costs and going to court and all that cost and time and effort, you can just say, well, at the end of the day, I have enough money here in my bucket from the retention sum to hire someone else to finish the job, and I just won't pay that to him. The next one is builder versus builder disputes. If you have a business partner, a shareholders agreement is absolutely essential. And there are several different special situations that happen in a building company that you need to be very protective of. Sometimes you will go into a business with someone that has the cash because you don't have the cash at the beginning. So you'll go in, let's say 50-50. And you go in 50-50 and now you have 50-50 votes. Your business partner doesn't have that building license. So if your company goes bust, you lose your building license, your business partner goes on, nothing happens to them. So what we normally do in these situations, we put special clauses into a shareholders agreement that deals with the situation where you're the one with the building license, your shareholder or your business partner is the one that doesn't have a license, and you end up getting the ultimate say about how you deal with certain issues because your building license is protective and you need to protect it or else you lose your income. We also put a deed of indemnity. We say something along the lines that if, as a builder, you are required to give a deed of indemnity to home warranty, to VMIA, to get your insurance upped, that means that if the VMIA ends up paying out a claim later on, after your company goes under, they can come after you personally for the amount that they end up paying out. And what you want to make sure is you bind your business partner to go in half and half with you so that they now have an interest in keeping that business going. So a shareholders agreement, it forces people, it says who can vote, how they can vote, what things you can do, what things you can't do, what happens if someone wants out of the business, what happens if someone wants to transfer the license, what you can and cannot do in terms of competitive businesses, if you want to sell, who can you sell to, but most importantly, dispute resolution. If there's a dispute, it forces them to come to the table and forces them to sit down with a third party to try to resolve that dispute. Sometimes people talk about, well, what's the difference between the RBN contract and all the other contracts on the market? There's just a few things that I'll identify now. One is that our liquidated damages are automatically set if you don't include anything. The other thing is we dealt with electronic communications, being able to accept text messages and emails as electronic communication. If you put their mobile number into the contract, or you put their email into the contract, have a look at that clause. It deals with acceptance of variations by email and things like that. We also have put an obligation on the homeowner to give you everything they have. And if they don't give you everything they have, they're liable to you. So if they have hidden any reports from you that are unfavorable, and so they went and got another report and they didn't tell you about that, then there is a circumstance where you can just pass the buck straight on to them. We talk about hazardous materials and substances in the demolition works. That's also, as far as I'm aware, not in any of the other contracts. And we also talk about materials supplied and installed by the owners. Normally that would go into a special condition that lawyers would draft up, but this says if an owner is going to supply that material to the builder, that material is going to be of merchantable quality, it's going to be fit for purpose, it's going to be delivered in accordance with your construction program, and then it will be installed by you, but at the end of the day, they're responsible for the product that they supplied. I just had a case where someone bought a product off, a plumbing product off the internet from eBay, plumber installed it on a Thursday, they went back to the property on the Monday, the entire house had been flooded. All the plasterboard, everything has to be ripped out. Who's responsible? The owner's responsible because the owner supplied the product. There was a special condition that passed blame onto the owner. They tried to blame the plumber, but the plumber, we were able to deflect that as well by saying, at the end of the day, it was the owner's responsibility. They warranted and promised that that was of merchantable quality. Having said that, I've also had a large case where a client ordered $170,000 worth of glass from China. And the builder went and said, is this actually compliant? And she said, sure. And she gave a certificate from a Chinese manufacturer saying, yeah, here's a certificate, it's Australian compliant. It wasn't. So, and the builder probably should have known it wasn't. So even if you get a product, you got to use your own due diligence to make sure it looks reasonable and it probably is compliant, and do your due diligence on that. We put another special clauses in about really warning the owners that they're not allowed on the property. They are not allowed on the property unless they get permission to come on the property, and it's a breach of OH&S. And you can point to these clauses in the contract, and you can say, you keep on coming to the land. This is breach of that clause. This is breach of that clause. You must not do it. We give an extra period of time, and we say that if you sign the contract in December, it's not going to be starting in December. It'll automatically be starting the following year. We go into extension time, some extra protections there. And in terms of the schedules, we've given you all the schedules as well. So that's about it for this presentation. And happy to answer any questions if anyone has any questions. Otherwise, thank you very much for attending. And if you have any questions, you can contact us at any time, or RBN.
Thank you, Damon, for that. That was excellent. Guys, does anyone have any questions? You can unmute yourself.
That was pretty good. There is one. It's probably a pretty simple one, but it's a good question. I was doing a job, just started probably about 6 weeks ago, and got delayed because didn't have we had a SOAR report. We didn't have a bar rating. Customer was saying everything's all good, and then it come to it, we needed a bar rating, and it was in a bushfire zone. And automatically, I knew straight away that the weather boards had to be changed on this extension. And I always said to the customer, we can put it as a variation when it comes to the stage. Is that the right thing to do, or should I have just redone the contract?
No, it would just be a variation.
Yeah, that's what.
And the reason is that it was if you look at the contract, the contract documents that are being provided, yeah, the owner has warranted that they're correct.
Yeah, that's what I thought.
And if they're not, then it's their fault, not yours, and you automatically entitled to a variation.
Yeah, that's what I thought. Yeah. I've been using that build exact variation, and they got stuff. The builder and the owner signs it, and the owner didn't sign one, but he already paid for it. And I said, look, you still need to sign it, even though you paid for it. You still need to sign it.
Yeah.
I said to him, because at the end it could bite me on the ass saying that you didn't sign for anything. And he said, yeah, is it good enough if I can just send you an email with the variation number? I was like, yeah, that's fine. So is that still a good thing to do? Just to say, well, if you can't sign it, at least send me an email saying I agree to this variation?
Yeah, they're actually on Friday, they're passing new legislation about signing of documents electronically.
Yeah.
But there's a lot of electronic signature platforms like HelloSign and DocuSign and things like that. But you actually have a special condition in your RBN contract.
Okay.
So if you can see that, let's just jump to it. And if I just go email, let's see what pops up. Or not. But let's jump to, you can still see my screen, yeah?
Yep.
Yep.
So first of all, we have a bunch of definitions that we've inserted. So we have information system, that's basically one of the definitions in legislation. So we have electronic communication. It means any communication in a form of data, text, or images by means of electronic energy. So this is like the legalese of emails and text messages. And it's also what's being defined in the legislation. And then we say, for the avoidance of doubt, this includes email or communication by email. And then we have a clause that says in the notices, in clause 38, it says that a notice is given by a person, delivered in person, fax, email, ordinary post, and is deemed served when they receive the email.
Because another thing, going back to that bar rate, and on the original quote I gave them, it said this quote price is due to about not being provided a bar rating and a soil report at that time, and so I could probably go back to that as well, can I? As well.
Yeah. What's important is you, at the end of the day, what you need to prove is VCAT is not going to really care that it's not an actual piece of paper that's been signed.
Yeah. Okay.
They don't care about that. What they care about is whether there's an offer acceptance. And so that's an agreement, right? A contract is you've made an offer, they've accepted the offer, both parties understand what that offer is. So that's the meeting of the minds. Now, if you say, here's my variation document, and they write back an email saying, yes, I agree, how in the world is that homeowner going to say they never agreed to it because they didn't sign it?
Yeah, okay, that's good. Yeah.
That the court will look, or the tribunal will look at them and think they're idiots, to be frank. And I've been in VCAT on dozens of times where a homeowner will get blasted by a member for saying, how are you even trying to say you didn't agree to this? You have an email right here saying you agree to it.
Yeah, okay.
And that's in writing. You can even do a text message saying, if you do the elements, hey, Joe, I'm going to, can we change this? This is going to be extra 4 days. It's going to cost you an extra $2,000. And I want you to pay it to the next claim. Is that okay? And if he writes back in text message, yeah, I agree. That's an agreement in writing. Good enough. Text message, nothing more.
Okay. And then
got to make sure you don't change phones and lose that text message.
No, that's fine. Yeah, just maybe screenshot it and send it to your email or something.
Yeah.
Another one, going back to the extension, where I was doing extension, as I was tying back into the original extension, the original house, all the house was termites all the way through it.
Yeah.
And I just fixed it straight away, saying
yes.
it needs to be fixed. I've told you about it, and they just said, yeah, go ahead. Because I said it's hard to put a price on it, because by the time I start ripping plasterboard or more plasterboard off, it's going to cost, it's endless. I don't know where it's going to stop. So
yeah,
it's a hard one when it comes to that sort of.
That kind of one is very difficult. What you need to do is you should be probably.
Would it be like agreement is take off plasterboard and then give them a quote? Or?
Yeah, that's exactly what you're going to have to do. You're going to have to break it down.
Okay.
because it's an unknown issue. It's a hidden site condition. So if you go into the contract and have a look at the clause that deals with it, so let's use that as an example. So if we go into clause 14 on page 33, and Jared, I'll get to you in a moment, but if you look at the clause 33, we have, oh sorry, page 33.
Page 33, yeah.
So if during the works latent conditions are discovered and the builder reasonably believes that there's a surface or subsurface condition to land, and it can also be to the property generally,
Yeah, okay.
right? Because that applies as well. Then you got to give notice, advise what it is. You might need to get extra tests done, and the owner will then have to pay all those costs. But you've got to follow the procedure, and certainly what you should be doing is breaking down what exactly you're going to do.
Yeah, okay.
I'm going to take off the plasterboard, or I'm going to take off the cladding or whatever it is, and I'll also put it back this much money. And then we'll investigate and see what it is, and then, yeah.
So obviously, something like could escalate very quick in cost.
Yeah, and in those circumstances, all you can do is just break it down and be very clear, step by step, what needs to be done.
Yeah, okay, all right, perfect.
Now, Jared wants to know what's the best way to start asking subbies to sign subcontractor agreements. And, you know, it really depends on the market. If subbies are busy, they're not going to agree to sign anything because they already have a lot of clients, and they're not going to just come to you and if you're forcing them to sign something. So it is difficult to get them to sign it, and not all subcontractors will sign it. And if you have a long history with them and you know them, then you're always better off keeping a good quality subby than going finding a new one, because a good quality subby can be hard to find, and a bad subby is the one that stuffs up your entire job. But as you get new ones, you slowly integrate that, you slowly get them on your subcontractor's agreement. And be very careful at Christmas time. I had one case where the house is a beautiful case. They couldn't find a painter. They hired a random guy that sent them a fax. And I don't even know who sends fax anymore other than lawyers. And they ended up hiring him, and he stuffed up the whole job. The whole job, everything, just total disaster. And something stupid like that, the most easiest job of the whole build, the paint job. I'm not saying, I'm not going to take away from painters, but the least complex job in terms of unknowns, and that can stuff up your whole job. So you got to be very careful on who you choose as subby, and making sure that if you are going to grab a subby, contact RBN, contact them, see if they have a referral. There's a good network there. A lot of the builders have mutual friends and the like, and a lot of the subbies are going through builder registration. And a lot of the trainers, and they know these guys, and they know who they are, and they trust them. And if you ever have a subby that stuffs you over, who's being referred to you by RBN, you got a better chance to work out your differences with them, because that subby will know that they'll lose the whole network if they don't do the right thing by you. So getting a referral is always really important if you can, and not just a Google search, because someone that's advertising on Google is probably advertising on Google because they're not getting any personal referrals, and they're not getting any personal referrals because they're probably not doing a great job. All right. Any other questions?
Okay. Thank you so much for that, Damon. That was amazing. Yeah, I think it's everyone's got a lot out of that. I know we did as well. So yeah, really appreciate your time and everything that you've done. So any final questions before we go, guys?
Damon, thanks very much for doing that. I was just wondering,
Not a
just so
problem.
that guys are aware of, obviously, you being a great partner of RBN. Can you just let them know of what your offer is to RBN mates to help them out when they contact you?
So I do have an offering, not on that slide. I actually haven't come up with an option for this presentation generally, but as an RBN member, you automatically get 37.5% all of our legal fees. So we end up charging, so most of my litigation files I charge $450 plus GST, which sounds very high, and it is very high. But we are, I guess, experts in domestic home building. And I've had clients that had lawyers that charge them 20 grand to do something. And I look at it and said, mate, we could have done that in 2. So even though we might charge high, we actually, we can get it done real quick, and we know the issues real fast. And a lot of the local suburb law firms just don't know that. So we're much more efficient, but the benefit is we only charge $300 an hour. So it's a lot less. The other thing is normally we charge fixed fee for everything. So if we're going to get engaged, first of all, you get a free call, chat with us for at least 30 minutes, working out your issue. All members get a free call. All members get to chat with us and run past their ideas being an RBN member. Number 2, during that call, we'll figure out what we know. If I can give you guidance immediately, I'll give you that guidance. If I know it in my head, I'll have a look at it and tell you exactly what to do. If we actually need to put pen to paper, normally I'll tell you, okay, fixed fee at a discounted rate. This is what we're going to do. We also have template documents that we normally offer significant discounts to, such as subcontractor agreements, you name it, we've got it. Warnings to owners about not attending site, dealing with the difficult clients. And a lot of times someone just wants to pick up the phone. A lot of the builders are on their own and they don't necessarily have someone just to call. And that's what we're here for. We're here for the builders. We don't act for homeowners. And we only act for builders. I'll just put a caveat to that. The only time we do act for owners is if the builder has gone under and they need a claim against home warranty insurance, or if the builder has done a very, very dodgy job and they're not an RBN member. So, yeah. We don't act against RBN builders, that's for sure. We're here to support you guys. Yeah.
No, that's great. Thank you, Damon. So yeah, if anyone needs that extra help, he's obviously there to help you guys out. But yeah, we'll get him back for sure. So we haven't seen the end of him. So thank you so much.
Not
and
a
thanks
problem.
guys for coming. Thanks for coming tonight. And we'll speak to you soon.
Thanks.
All right. Thank you very much. Talk to you later.
Bye.
Thanks, guys. Bye.
All right. Bye.